Well, why are we still talking about him today? Because almost every day there's something in the news that ties back to something that Jackson did, whether that be an executive order or something happening in the international criminal world or some cases in the Supreme Court that go back to his cases. So there's a long legacy here. And he's from Western New York. And I think that's something that we can all be proud of. So thank you for asking. Yeah.
You said the Nuremberg trials, there were 19 perpetrators that were found guilty. What happened to those?
They were acquitted. So they sort of went on with their lives. As in any trial, if you're acquitted, you just go back to your life. Now, I will tell you, actually, 2 out of the 3 were defendants in later trials as well. So 2 out of the 3 were found guilty of something else. But one of them just sort of went back to his life. Yeah. Yes?
Do you know what they were found guilty of?
So there were 4 crimes at Nuremberg. One was a crime against humanity, a crime against peace, war crime, and then a conspiracy to commit those. And for the most part, all 22 were charged with all 4 crimes. And actually, one of the reasons the 3 were acquitted is there were 3 that weren't charged with all 4. So I can also tell you, of the 19, 12 of them were sentenced to be hanged. 10 of them were actually hanged. 1 was actually tried in absentia, so he wasn't there in the courtroom to be hanged. They figured they'd carry that out when they found him. And 1 was Hermann Goering, who did not think a hanging was a dignified enough death for someone of his military stature, so he had petitioned the court to be shot. And the court denied that request. And so about 2 hours before his hanging was scheduled to be carried out, he committed suicide via cyanide pill. So, and then of the other 7, 3 were given life sentences and 4 were given terms between 10 and 20 years. So that's what happened to them. Any other questions? Yes? It does not. That's how the justice system works. So the Fifth Amendment is against incriminating yourself. So you don't have to speak against your own interests. Right. Yes. Yeah. Yeah. Double jeopardy. Yes. So yes, that's if you have been charged with one crime and you go through the process and you are found not guilty of that, you cannot be charged for that exact same thing again because you've, yeah. Of course. Yes. Good. Great. Thank you. Sorry.
Are you ready?
Yeah.
Because we have everybody ready. Okay. I don't need to say.
So you're the president here in this courthouse. Like, what's the most major case that just happened?
So I'm actually not the president of this courthouse. The Jackson Citizen case.
Give everybody up.
Yes, right.
My judges. He knows how to. We're gonna bring everybody in.
Colleen. Here, keep the door open, and I'll hear him coming. There. Good morning. Welcome to the Robert H. Jackson Courthouse. My name is Mary Loneguth. I am the clerk of the court, and I wish to welcome you all here today. So, here's how we start a court proceeding. Oh yay, oh yay, oh yay. All rise. Good. The United States District Court of New York is now in special session on this Thursday, September 25th, 2025, in observance of Constitution Day. Presiding is the Honorable Lawrence J. Velardo, joined by many of our judges and other dignitaries.
Mr. Plessy. Ms. Ferguson.
Good morning, everyone. You may be seated. It's so nice to look out at all these happy young faces today. Welcome to the United States District Court for the Western District of New York. My name is Larry Villardo, and I am a judge on the court, and it's my pleasure to welcome you here today for what I think is going to be a fabulous program. You know, the Supreme Court is sometimes criticized for not following precedent, changing precedent, but I think, as the Chief Justice said when he was here a couple months ago, that we all can agree that there are certain times when the court should not follow precedent. And one of those times, I think we all would agree, is when the court decided Brown versus the Board of Education, overruling the precedent in Plessy versus Ferguson. So it's a thrill for me today to be here to hear about Plessy versus Ferguson from Plessy and Ferguson, from descendants of the folks who were the parties in that case. Before I turn the program over to Mike Purley, who's responsible for putting it together, let me introduce some of our dignitaries who are here today. In front of me are two of our magistrate judges in this court, Judge Les Fascio and Judge Jerry McCarthy. Judge Carl Buckeye is seated to my left. And then in the jury box, Judge Jeanette Ogden of our Appellate Division, 4th Department. That's the appellate court. I think I argued there about 150 times. Next to her is someone I refer to as my little sister, Judge Amy Martocci. She's the administrative judge of the 8th Judicial District, and Amy and I were partners together at my law firm and are to this day very, very close, almost like brother and sister. Judge Susan Egan of the Erie County Court. Judge Jahar Pridgen, Chief Judge of the Buffalo City Court. Judge Barbara Johnson Lee of the Buffalo City Court. Next to her, Professor Matt Stylen, Vice Dean at University of Buffalo Law School. Then next to him, Joshua Cohn, a lecturer in law at UB. And then Mike Purley, who's putting this program together. In the next row, Audrey Seeley, an attorney with the U.S. Department of Energy, Office of General Counsel. Douglas Hopkins, the steering committee of the James Otis Lecture Series. Deborah Trapp Thompson, president of the Foundation of Abota, who's sponsoring this. Mary Starr, a clerk at Hurwitz and Fine.
Who will be the new clerk of court when Mary retires. Give them a round of applause. I want to personally thank today, and I'll thank her again tonight, the person who made the longest journey to get here from Orange County, California, Deborah Trapp Thompson, president of our Abota Foundation. She was really, it was really hard to get her here. I said to her when we were at a conference in Banff, I'd like you to come to the James Otis lecture in our fair city of Buffalo on September 25th. She said, send me an email with a date. And she's here. So you don't get here by accident, folks. You earn your way into this room. The James Otis lecture is designed for students who are dedicated to academic excellence. And your dedication to academic excellence was your ticket into this courtroom today. So congratulate yourselves for that and take advantage of an opportunity that does not come to very many people very often. It is my distinct pleasure to introduce Joshua, professor at a lecturer at UB Law School. You've read his bio. But what you don't understand about the people at UB, and I include Vice Dean Stylen in this, is the amount of time and effort they put into the remarks that they're going to present to you today. On Saturday, I think it was, we spent half an hour on a Zoom call because he wanted to get it right for you. So would you please join me in welcoming Joshua Chain?
Hello. It is great to be here. I really do want to give my thanks to Michael, to Matt, to Judge Lardo, for everybody involved in putting on what is, I hope and know, going to be a really wonderful program. I especially want to thank the descendants we have here today from the original litigant and judge in this case, Keith Plessy and Phoebe Ferguson. This is an amazing honor to be able to talk about this very important and unfortunately tragic case in American history. I also wanted to mention, too, that when I was asked to give this talk, it kind of almost was like a moment of like full circle for me in a way. When I was an undergraduate student at Pitt, I was in a history program and I did a history honors thesis on disfranchisement in the American South in the 1890s. And one of the people who kept coming up in a lot of the history I was reading was a man named Albion Turgey. And I read a considerable bit more about him than I probably needed to at the time to do this honors thesis. But I thought he was such a fascinating figure, a committed civil rights attorney, a judge in North Carolina during Reconstruction. So it is kind of just an amazing coincidence and honor to actually be able to talk today about his work as a lawyer. This is the first time I've had an opportunity to really dig into some of the arguments that he made in this case. And I think they have a lot of a kind of modern feel to a lot of the critiques that he had at the time of the statute in Louisiana that was the subject of this case. But also, I think, too, just on a lot of the kind of practices and assumptions of white supremacy in the 1890s, which I think in some respects are still with us today. So, to begin with, I would like to mention that this case, Plessy versus Ferguson, is now seen, I think quite rightly, as one of the High Court's most misguided and unjust rulings. It became a kind of cornerstone in the legal edifice of Jim Crow segregation, in particular, the concept of separate but equal. But this case is also known for a very notable dissent by Justice John Harlan, especially his argument, and I'm quoting here, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens." This concept of legal colorblindness would become very influential, but also very contested. In my remarks today, I would like to contextualize the decision in Plessy versus Ferguson as part of a broader effort to reorder and remake white supremacy in the last decades of the 19th century. The Plessy decision was not the cause of these changes, but it lent considerable legal legitimacy to them. And it signaled to both Black and white publics in the South and in the nation as a whole that the federal government's commitment to the cause of emancipation, the full citizenship of African Americans, and a broad interpretation of the post-war amendments had all but come to an end. I will also discuss some of the unusual ways that the ideas about race and color especially factored into the legal strategy of Homer Plessy, the plaintiff, and the lead attorney in this case, Albion Turgey. Plessy was, by most accounts, discernibly white. Having 1/8 African heritage, he could pass as a white person. His color, in the language of the time, had to be announced by Plessy before he was arrested for entering and refusing to leave a railroad coach car reserved for white people. Albien Turgi, Homer Plessy's attorney, hoped to show that Louisiana had violated the 13th and 14th Amendments of the Constitution by the very act of assigning people to either a black or white, a colored or white racial category, and the corresponding railroad cars. But first, I want to turn to the historical context. What was going on in the country around this case at the time? Because I think it's very important to understand the issues of white supremacy and racial hierarchy, because they are at the heart of this case. Especially because this case involves what was read by many people, including the author of the majority opinion, as a seemingly neutral concept of equal but separate, or separate but equal. Both framings were used a lot at the time. So, the Plessy decision came about at a time of profound decline in the legal rights for African Americans throughout the South, and it involved protracted campaigns to remove them from full participation in public life. This period was often linked, these movements were linked at the time to the emergence of a kind of radical form of white racism from about the late 1880s onward, premised on an alleged threat posed by African Americans who had never experienced the supposed benign tutelage of slavery. This radicalism, this radical racism emphasized concepts like racial degeneracy, savagery, and criminality. It's something, if you look at newspapers from this time, these kinds of assumptions run throughout them. African American men in particular were seen as posing a sexual threat to white women. A lot of laws created at this time, segregation laws, were premised on this idea that it was for the protection of white women. Perhaps nothing more exemplifies the intensity of this form of white supremacy than the issue of lynching. In the 1890s, late 1880s and 1890s, there was a massive increase in the number of recorded lynchings in the country. According to a database that's maintained by the University of Missouri Kansas City Law School, between 1889 and 1901, there were at least 1,416 African Americans killed in lynchings. The true figure is probably considerably higher than this. A lot of these kinds of incidents were not recorded and committed to memory. These killings, often euphemistically attributed to persons unknown, often involved entire white communities. They were frequently very public and highly organized events. Beyond the immediate victim of this kind of violence, these lynchings, as public, popular expressions of white supremacy, terrorized African American communities and always lurked in the background of other efforts to restrict their rights. The 1890s also saw a dramatic reduction in the voting rights for African American men. If you'll recall, women did not have the right to vote at the time. The franchise had been extended after the Civil War to African American men, but during the 1890s especially, this was dramatically reduced. In fact, as the events of the Plessy and Ferguson case were occurring, white political leaders in Louisiana were trying numerous methods to disfranchise substantial portions of the state electorate. A new constitution, adopted in 1898, contained numerous hurdles for potential voters, a whole bunch of different registration requirements, poll tax, a literacy test. All of this effectively removed most African Americans from the electorate by the 1900 election. In addition to this, there were a lot of laws that we commonly think now of exemplifying Jim Crow segregation that developed in the 1890s. This is not to say there had not been previous forms of separation between the races. In fact, after the Civil War, one of the first major acts of refiguring the kind of relations, the spatial relations of African Americans and white people in the United States was the breakup of the plantations that many African Americans wanted to have their own family farms and not be located so closely to the previous slave owners. But a lot of the separation that it had occurred in the aftermath of the Civil War and after Reconstruction, immediately after Reconstruction, was especially the actions of a lot of private actors. It was not until the late 1880s onward that state legislatures got very, very actively involved in mandating comprehensive segregation laws to reorder public space according to racial categories. These laws varied from state to state, but they came in three large waves, from the late 1880s to about 1893, again from 1897 to 1907, and then a later period from around 1913 to 1950. Interspersed in between these large waves, there was a constant flux of new laws mandating segregation in more and more spaces. Now, the first two waves of this kind of movement focused on areas of public accommodation, including several different forms of common carriers, like trains, streetcars, steamboats. The third wave was mainly focused on segregating areas in new industrial and urban settings, like public toilets and factories. Any place that might be more closely linked to the possibility of heterosexual contact or intimacy between the races, the more likely it was to become subject to these kinds of segregation laws, especially if these places in some ways resembled the home. Thus, hotels, schools, theaters, restaurants were areas of frequent separation, and some of this had predated the 1890s as well. But the laws that came in the 1890s required these areas to be segregated. The means of travel especially became a focal point of a lot of this legislation. Even more so, as a lot of these kinds of areas, trains especially, became more important to Southern society as it recovered from the war, Reconstruction, and began to modernize. Between 1887 and 1891, 9 Southern states enacted railroad segregation laws. Rather than denying service to African American patrons outright, these laws required separate accommodations for each race. They also required, at least in the construction of these statutes, that these separate accommodations be equal. The Separate Car Act, as it's often referred to in Louisiana, which was challenged by Homer Plessy, was a product of this first wave of segregationist lawmaking. The language of separate but equal, or equal but separate, in these statutes was specifically designed to avoid violating the 14th Amendment's Equal Protection Clause. This is a clause at the end of the 14th Amendment that says that state governments are required to apply their laws fairly and equally to all people in similar situations. Treating people differently, if it's to be done at all, must be based on a valid reason. The segregationist carriage laws attempted to sidestep this clause by pointing out that providing the same accommodations, supposedly equal, for members of each race fulfilled the requirements of equal protection. Such laws, it was argued, applied equally to both black, colored, and white. Some of the early statutes in this wave only required that carriers, railroad companies, provide separate accommodations. They did not require them, the laws that is, did not require the railroads to actually do the act of separating, to force people into the different cars. Later laws, including Louisiana's Separate Car Act, did require this kind of racial sorting, and it empowered railroad employees, private actors of a private company, and empowered them to make these kinds of decisions. Now, of course, these railroad cars were rarely equal. The conditions in them were often very much not equal. Some black litigants sued railroads precisely over these unequal conditions, and they occasionally won, kind of forcing conditions to be improved on those separate cars. But the separation itself was a more fundamental problem. It was meant as a way to demean and humiliate African Americans. It was a ritual of racial classification and exclusion from public life, performed in a very public manner, a very public setting. Clearly inferior conditions in cars assigned for Black people compounded the indignity of this act of separation. As historian Joel Williamson wrote many decades ago now, like arbitrary disfranchisement, arbitrary relegation to always inferior facilities was a sign of where the power actually lay and where it would likely lie in the future. It was this aspect of the Separate Car Act that Homer Plessy challenged and that his lawyer, Albion Turgi, wanted to focus on in their case. So when the Separate Car Act was enacted in 1890, it immediately provoked an effort to try to get it struck down. The appropriately named Citizens Committee to test the constitutionality of the separate car law raised a bunch of funds for a test case. They hired Turgi as a lawyer. He was a well-known figure at this time. And he was well known for continuing to believe in a lot of the radical republicanism that had animated congressional Reconstruction decades before. He was very well known as a defender of civil rights, and they reached out to him in particular, who was, I believe, living at the time in Western New York when this case started. So Turgi knew from the outset that this would be a very hard case to win. It would be very hard to convince most of the judges to take the fact of white supremacy and the intention of the law into consideration. Much more likely was that the judges would read the law in a very, very formal manner. They would only look at its written text, what it actually said. Because the Separate Car Act required equal but separate accommodations, it appeared on its face to treat both colored and white passengers equally. To try to get the justices to recognize the kind of white supremacist logic of this and the context in which this was occurring, Turgi developed a really unusual legal strategy that focused very much on that act of classification that the railroad employees had to engage in. How were they sorting people by race? How were they sorting people by color? Quoting from Turgi's brief to the court, the gist of our case is the unconstitutionality of the assortment, not the question of equal accommodation. We insist that the state has no right to compel us to ride in a car set apart for a particular race, whatever it is, whether it is good or as another or not. So the best way to approach this, Turgi thought, was to try to find a plaintiff who might not fit the racial classification scheme that was in this statute. This statute had very binary categories, colored and white. So the idea was to show how this scheme was unworkable and unjust because of its unworkable quality. After a failed first attempt at trying to find a plaintiff for this case, the Citizens Committee selected Homer Plessy. He was a person of 1/8 African heritage or 7/8 European heritage. And in addition to finding somebody who seemed to not quite fit this racial classification scheme, the committee also approached several railroad companies about whether they wanted to participate in this case. A lot of the railroad companies did not like this law for the simple fact that it was expensive for them to make it work. They actually had to provide extra cars. So in June 1892, Homer Plessy purchased a first-class ticket for the East Louisiana Railroad. He boarded the car reserved for white people, and he announced his colored heritage to a conductor who was expecting him. Plessy was arrested and charged with violating the Separate Car Act. Plessy argued that the law violated both the 13th and the 14th Amendments, but Judge John Ferguson ruled that since the railroad only operated within the state, it didn't go beyond state borders, it did not violate some previous rulings that had declared this kind of separation on an interstate railroad to be unconstitutional. Plessy challenged this ruling first to the Louisiana Supreme Court and then later to the U.S. Supreme Court. Turgey's strategy emphasized that no form of racial classification would ultimately be adequate because it would always be arbitrary, because race and color were so difficult to define. But more importantly, it was not simply a matter of trying to find neutral, effective, proper categories to assign people to these different cars. Because just the act itself was an act of racial domination. It was a form of public humiliation. It was a way that white supremacy was being reasserted in this decade. Turgey tried hard to get to the justices in this case to acknowledge this, and in a way, he kind of played to what he felt was their racist common sense. Turgey argued that in this context, there was an inherent value to being white or being considered white. And he posed this kind of question, this example, this thought experiment to the justices. I'm quoting here. How much would it be worth to a young man entering upon the practice of law to be regarded as a white man rather than a colored one? According to Turgey, you could think about whiteness almost as a form of property. And if you were assigned to a car that didn't correspond to what your view of your race, your color was, it would be in effect like taking your property. And the act in question required conductors on the railroad to determine whether if someone was white or colored. If they assigned a white person or a person who could pass as white to a colored car, they were, in Turgey's argument here, they were harming a person's reputation. They were damaging a person's property. And they were doing so in a very arbitrary way. And Turgey emphasized the arbitrary nature of these categories through the plaintiff Homer Plessy, who did not seem to really fit in these categories. It highlighted how arbitrary these kind of racial classifications were. Turgey went on and he listed over 20, I believe, different state laws from across the US that tried to define racial categories. And the effect was to show how much it varied from place to place, how unstable this was. And he criticized the Separate Car Act because it provided no guide for railroad conductors on how to do this. So in addition to the Fourth Amendment requiring equal protection, it has another clause in it as well that prohibits a state government from depriving any person of life, liberty, or property without the due process of law. This is often referred to as the Due Process Clause of the amendment. The Separate Car Act's requirement for color classification violated this due process requirement because it deprived someone potentially of a property interest in whiteness. This also meant, conversely, that there was a reputational quality of inferiority to being labeled colored. Now, the majority opinion writer in this case, Justice Henry Brown, he rejected this argument. He refused to directly acknowledge that the intention of the act was to legally entrench racial subordination and white supremacy. He argued, and I'm quoting here, the underlying fallacy of the plaintiff's argument is to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it's not by reason of anything found in the act, but solely because the colored race chooses to put that construction on it. In effect, he was blaming the colored race for their own, this label of inferiority. He was not acknowledging that the act itself was what was producing this. Justice John Harlan, in dissent, excoriated Justice Brown for his willful blindness to the realities of racial subordination, the real reason why this act was created. Quoting Harlan, "Everyone knows that the statute in question," emphasis in original, "everyone knows that the statute in question has its origin in the purpose not so much to exclude white persons from railroad cars occupied by blacks, but to exclude colored people from coaches occupied or assigned to white persons." Justice Harlan's famous quote that our Constitution is colorblind and neither knows nor tolerates classes among its citizens was also a part of his criticism of Brown's opinion. But it was not meant in a way to ignore race, to not see it, to not acknowledge racial hierarchy, but to point to the ways that these aspects of our society worked through a seemingly neutral rule that helped create and endorse this kind of white supremacy, this kind of segregation. So, I want to wrap up by relating an account by a young man who was traveling in one of these separate cars, not in Louisiana, but a very similar one in Mississippi nearby. He related his account of this trip that he was taking in Mississippi to the great newspaper, the Chicago Defender. And he said that this separate colored car was universally filthy and uncomfortable, that it was a place of indignity and disgrace and shame. I'm quoting here. The car was a disorderly jumble of various different people, of cargo, and of animals. It was used by families, but it was also used by various workmen with all their assorted equipment. A deputy sheriff was there escorting 6 shackled black men headed to the state prison farm. There were also chickens and other livestock crowded into this car, in addition to large amounts of baggage and boxes. The intended degradation was obvious. The intended humiliation was obvious. In his words, quote, "No grander lie was ever enacted into law than that declares separate but equal accommodations. There will never be equal accommodations for the race. Separation presupposes and invites inequalities." Thank you.
I was about to exercise a point of personal
Okay. So for those of you who don't know me, my name is Kristen McMahon, and I have the privilege of serving as the president of the Robert H. Jackson Center. And it's quite a privilege to be in conversation with Keith and Phoebe. I consider us old friends at this point. So let me give you a brief introduction. Phoebe Ferguson is a native New Orleans and the great-great-granddaughter of Judge John Howard Ferguson. In addition to her work with the initiative of Plessy and Ferguson, she is the founder, producer, and director of Bayou and Me Productions. The New Orleans-based studio collaborates with community members and local organizations to make films on pressing social issues, including the need for equitable, community-based public schools. Phoebe studied at Art Center College of Design, New York University, and at Tulane. Keith Plessy is a native New Orleans as well, from the 7th Ward, and a first cousin 3 times removed from Homer Plessy. So see if I can do this math, great-grandson of Homer's cousin.
Correct.
Thank you, okay. Plessy has worked in the hospitality industry at the New Orleans Marriott for more than 40 years, since his graduation from the New Orleans Center for Creative Arts in 1976. And 3 years after graduating from the New Orleans Center for Creative Arts, he designed and painted the images of more than 100 famous African Americans at his former elementary school, the historic Black institution, the Lena C. Jones Elementary, as a thank you to his early childhood teachers. Something for you students to think about. How would you thank your teachers? In 1997, Plessy met one of his heroes and a leader of the modern civil rights movement, Rosa Parks. And Rosa said to him, "Your name is Plessy. You got work to do." The Plessy and Ferguson Initiative was founded in 2009 by these 2 descendants. And as you've just heard from Professor Cohn, the landmark Plessy v. Ferguson United States Supreme Court case, which upheld the constitutionality of racial segregation in the United States. Plessy and Ferguson works and focuses on civil rights history, memorialization, and transitional justice. Keith and Phoebe, I suspect this is the first question that you always get. There's perhaps not a natural intersection between your lives prior to your meeting. So how did you first meet each other?
May I go first? Okay. I'd like to give credit to a famous author named Keith Weldon Medley, who may he rest in peace, passed away recently. His book, We as Free Men, was written when Phoebe met him in 2001 or so, 3? And I met him in 1996. But eventually, he knew what he had in his book after 25 years of research, because he researched the case, the Citizens Committee, and everything that happened in New Orleans. So he knew what he had when he had Phoebe and I, so he put us together at his book signing. And when we met, I guess the first thing Phoebe did was apologize for history. And it was a shock to me. And what I did automatically out of my heart was say it's no longer Plessy versus Ferguson, it's Plessy and Ferguson. And we became friends.
This photograph captured the moment that we actually met. I didn't know I was going to meet Keith. Keith Medley had set it up, and he just said, "I'd like you to meet someone." And I walked in, and Keith came over and said, "Hi, I'm Keith Plessy." I'm Phoebe Ferguson.
And then, so Keith, you uttered the famous words, Plessy and Ferguson. Yes. How did the foundation come to be? How did this initiative start?
Well, we formed the organization in 2009 in July on the 9th of July. That was the day that the 14th Amendment was signed, was ratified, I think. And we were not aware of that either.
It's funny that kismet sometimes happen like that.
Yes, but that first year we marked the spot in February on Keith Weldon Medley's birthday with a marker that we have honoring Plessy versus Ferguson. We were not even an organization yet, but we announced that we were going to form the organization on that day.
That's great. Phoebe, anything you want to add to that story?
I guess. So Keith Medley was the inspiration for